attorney Laura Anthony, founding partner of Legal and Compliance, a full-service corporate securities and business transactions law firm. Today is the continuation in a LawCast series talking about Regulation A. Regulation A includes a limited integration safe harbor such that offers and sales under Regulation A will not be integrated with prior or subsequent offers or sales that are registered under the Securities Act, made under compensation plans relying on Rule 701, made under other employee benefit plans, made in reliance on Regulation S, made more than 6 months following the completion of the Regulation A offering, or made in crowdfunding offerings exempt under Section 4A6 of the Securities Act, which is Title III crowdfunding. The SEC has also confirmed that Rule 152 applies to Regulation A offerings, such that a completed exempt offering, such as under 506B, will not integrate with a subsequent Regulation A offering. In the absence of a clear exemption from integration, companies would turn to the fact-specific 5-factor test to determine whether the Regulation A offering would integrate with one or more other offerings. The following factors, 5 factors, need to be considered in an integration analysis. Are the offerings part of a single plan of financing? Do the offerings involve the issuance of the same class of securities? Are the offerings made at or about the same time? Is the same type of consideration to be received? And are the offerings made for the same general purpose? In addition to the basic requirements that apply to all Regulation A offerings, Tier 2 offerings also require audited financial statements, though I note that many state blue sky laws require audited financial statements as well. So even if you're under Tier 1, you may have to have audits for your state blue sky compliance. Okay, Tier 2 also requires ongoing reporting requirements, including the filing of an annual and semi-annual report and periodic reports for current information. And these are on Forms 1K, 1S, and 1U. And there is a limitation on the number of securities non-accredited investors can purchase, and that limitation is no more than 10% of the greater of the investor's annual income or net worth. It is the obligation of the company to notify investors of these limitations. However, the company may rely on the investor's representations as to accreditation and as to investment limits. Regulation A allows Tier 2 companies that follow an S1 format for their Form 1A to file a Form 8A concurrently with the qualification of their Form 1A. With the filing of a Form 8A, the company registers under the Exchange Act and becomes subject to the full reporting requirements of the Exchange Act. In addition, the company could then qualify to make an immediate application to a national securities exchange such as NASDAQ or the NYSE MKT, assuming, of course, that the company meets the other qualitative and quantitative listing standards. Where the securities will be listed on a national exchange, the limitations on the number of securities that can be purchased by non-accredited investors will not apply. Where a Tier 2 company does not file a Form 8A, they are only required to file ongoing SEC reports under Regulation A, which is the semi-annual and annual reports. Although these reports are substantially similar in form to a current annual report on Form 10K, the company will not be considered subject to the Exchange Act reporting requirements for purposes of the shorter Rule 144 holding period if they are only a Regulation A reporter. I'm securities attorney Laura Anthony, founding partner of Legal and Compliance and producer of LawCast. Should you have any questions about today's topic, please visit securitieslawblog.com and lawcast.com or contact me directly. Inquiries of a technical nature are always encouraged.